To these people that joined the church back in 1840 in Indiana.
Go ahead and call the meeting to order and then.
Relative.
Here now, Jake Thomas is on the wrong gambling.
Everybody.
Do they need to start the meeting, their meeting themselves?
Yeah, well, you'll start it and then they'll start it.
It works.
All right, I'd like to call this meeting to order. This is where is it? This is a joint meeting, work meeting between the Grantsville City Council and Grantsville Planning Commission. Today's date is Tuesday, November 18th, 2025, at 6 p.m. This meeting is being held at Grantsville City offices. All members of the Planning Commission are present except for Commissioner Dwyer. And is Chris a full-fledged member yet? No? Okay. So she is gone.
We announced that our alternates are not.
And none of our alternates are present either.
And then Brett, if you'll, or Heidi, if you want to call the meeting to order and then just note that Jake Thomas is joining.
Is he on Zoom?
Yeah, by Zoom.
Is Jolene attending?
No.
Okay. Like to call the meeting to order. We have Councilman Butler, Councilman.
Actually, the mayor's right there.
Oh,
So
I didn't even see him.
Why
Sorry,
am I
Mayor.
doing
the
this?
mayor's right there.
All right,
It's just like, I swear the mayor walked in. So, hey,
I was
little premature, but come up here to the podium.
just chuckling.
Hey,
Sorry, I did
public-
not see you.
Public comment. Come up right to the podium. Thank
Come
you.
in the back door.
No, he came right in. I was just like,
Okay.
why is she asking me? And then,
Let's call this
council meeting to order.
I texted you, so you can text Jake. I don't have Jake's number. For the Zoom meeting, he's on the wrong one.
He's on the wrong one?
Yeah.
Okay.
Thanks.
So you're getting taken care of?
Yeah, we're getting it taken care of.
Okay. So calling this the Grantsville City Council together for a joint meeting with the Planning Commission. And attendance are so far, I'm Neil Critchlow, Jeff Williams is here, Rhett Butler, Heidi Hammond, and Jake's is on the Zoom pretty quick.
Jolene will not be in it.
And Shelly will not be in attendance. And the time over to you.
Thank you. Jordan with the ombudsman, I can't ever say that. Ombudsman's office. He's in traffic, so he's a little delayed. Is there anything we would like to discuss together before he gets here? Any questions we have on conditional uses that we're gonna go over?
Yeah, I think it would be appropriate to maybe have discussions between the council and the planning commission with questions that they may want to ask. Jordan? Any specific topics for Jordan that you guys would want to discuss? That way we can note it down.
I can't think of any specific questions right now. I'm sure things may come up. I'm just looking forward to hearing what he has to say and what type of training he's gonna give us. I mean, I think it'll only help, especially for future decisions down the road, so. From my perspective.
So is he just like real estate property rights, or does that include water property rights?
It's conditional, we're talking training for conditional uses.
Okay.
Yeah, so he's the lead attorney of the office of the property rights office. So we've had Jordan, come out and present the city before. I think it was very beneficial, more of just an overall general training that he provided. That, you know, addressed planning commission's role and city council's role, and then, conditional use permits, subdivision applications that they, would address, and any new updates, legislative updates through the state. While we are talking about legislative updates, they have actually changed. The LUDMA has been updated, and it's changed from 10-9A to chapters 10-20. So just so that you're all aware, when you guys are trying to find applicable state codes, it's actually now 10-20. And That's Jason.
Yep.
Thank you. Jay, did you see Jordan out there? From the ombudsman's office?
There was a car.
I have one question, and I'd like to get, I guess, people's thoughts, and you brought this up to you a little bit, Shelby, but two of the meetings I've been in, we've talked about people coming in with utilities, and that's where they want to put some structure basically that was in contradiction to what the city code allows for, and I know we've come in and we've approved two of those, the ones I've been in with so far. Is there interest from the city council or concern if we were to try to make some kind of amendment where Shelby would be able to approve some of those if there's some conditions met outside of that? Because some of these people are coming in, everything's developed around them, they get clearance from all utilities saying there's no interest in doing that, but they still have to go back and apply, pay a fee to come back into the planning zone just to say, can we put a shed here when we know based on the condition that there's no other real development risk for the city? I know there's a reason that's put in place for future development, but if there's a reason to clause around that to where there's no real risk, is there a reason that we have to have that seen? I'm just curious to get people's
I
thoughts.
have a comment about that, just from my perspective. In every case, when we've tackled that issue, there's always been, Public Works is pretty strict, pretty black and white on whether or not it's allowed or not, and it's always a no, and that is Public Works right to have that opinion. So it'd be hard, I think, from a city standpoint, and correct me if I'm wrong, Michael, but I think it'd be hard from a city standpoint to have two individuals with contrasting views overruling one or the other. I think it would need to circle back through the process with P and Z. That would be very difficult to have like Shelby overrule Christie in something that she essentially said no to, so.
I just think there needs to be an amendment that able to shorten those distances that those people are asking about. And was established.
So what if we,
What's too close?
We have denied some too, just so you know.
Well, not that I have it here,
Yeah.
but I'm wondering, Spucky, on that, I know the city's come back and Christie had said no, and they're staying within what they have, but it would be more of a direction to say, look, the city's not at risk for maybe her reasons to say no or justified, or maybe they're just based on what the code says and she's just gonna say no because that's what it says. I'm just trying to make things a little bit simpler for the.
She is very black and white. It's either this is
Yeah.
the rule or
Oh,
not,
absolutely.
which is great. Okay, and maybe there ought to be some type of a review process between Bill and Christie and Shelby that they can review the request and be able to make a judgment off of that.
yeah,
Like an appeals group. Either thing.
I think Mayor nailed it on the head. If we had a review process that says, okay, if they meet A, B, C, and D standards, and the city engineer and the public works signs off on it because they meet these standards, then yes, but if they both can't come to an agreement, then it would come to the planning commission. Same
I'm just
thing,
throwing out an idea. Like I said, you might want to say you keep it the same. I'm just giving one opinion, so.
same thing with, a development, let's say the DRC, I have a different opinion on all access to a lot versus what the engineer has. And instead of, having our differences, we would just bring it to planning commission and you guys would make the decision. Then you guys are the bad guys and Barry's not, or I'm not.
Or vice versa.
Vice versa. I could be the bad guy,
It could be.
not opposed to it.
We've seen so many, and I think Derek can agree with this. We've seen so many different situations though. It's kind of nice to have a body of 5 people to discuss through the issue at hand and to be able to tackle.
Yeah.
I do think there's value in bringing it to the planning commission. I think there's value. That's just, it is more work.
Jordan, how are you?
Hello, you guys waiting for me?
Yeah.
All right, sorry I'm late. I rolled the dice and got the car wrecked.
Oh.
I didn't wreck the car, but the car wrecked.
Oh.
Do you have any connections with UDOT? Could you call them and express to them your frustration?
I've tried that,
Okay,
but
we're just wondering if you have connections.
Not like that.
Do you
No.
wanna, do you wanna call the first agenda?
Oh, yeah, okay. Now, Jordan has showed up. Thank you for coming. We'll go ahead and move on to agenda item number one, training with the property right ombudsman.
Do I
You
just
wanna
hook
move
up
it
here
ahead?
or what's the best
Yeah,
way?
you can do that.
Okay. Oh, you have it up already. Should we just use yours or use mine?
Whatever you want.
We just lost it.
I changed it.
Oh, okay.
You wanna,
Traumatized. Thank you for getting the system up and running again, whoever did that.
All right.
maybe.
Okay. Thanks for having me. So my name is Jordan. Let's see. Now we have, is this the planning commission?
Yes.
Okay,
We
great.
have the city
And then
council
city-
behind you.
And city
City
council
council's
behind me.
here.
Do we want, is this okay? Is this format okay? Should I stand somewhere else?
That's absolutely.
You want to be behind? Okay. Look at my beautiful bald head. All right, my name is Jordan Cullimore. I am the lead attorney in the Property Rights Ombudsman's Office. Again, apologies for my late arrival, but thanks for having me. I find it's useful to start out just by talking a little bit about the Ombudsman's Office, what we do, who we are, kind of the resources that we provide. So, you know, everyone always asks the first question, what is an Ombudsman's Office? Or an ombudsman, right? So we're a government appointed individual tasked with investigating to resolve disputes against the government. Our office was created in 1997. Here's some of the main roles that we play and the services we provide. So with takings and eminent domain, right? When the public needs private property for public use, we get involved to mediate those disputes between the property owner and the government, and we can provide resources to the property owner and information and a second appraisal and different things like that. In the area of land use and development, we primarily provide the advisory opinion. So if there's a dispute over a land use application, one or the other party can actually come to our office and we do a little bit of investigating, and then we can produce an opinion that works as kind of a dispute resolution tool, right? And then we obviously come around and do trainings, and we also provide grants. So does anyone have any questions about the office and what we do before we jump into the fun stuff? And how much time do we have? When should we end?
We got till about 5 to
Yeah,
7.
45 minutes.
Okay, 45 minutes. I figure you probably want a little break before your main meeting, right?
Yeah, so maybe let's 6:30-ish.
Okay,
6:35.
6:30?
Yeah,
So
we'll play
like-
it by ear.
Oh, 15 minutes?
That's only 15 minutes.
Okay, 6:45.
We'll go fast. So conditional uses, when I talked with Bill, who I understand got out of the meeting tonight, how'd that happen? He said that you guys wanted some training on conditional uses. I like these to be conversations, right? So any questions you guys have, anyone has about anything, let me know. We can talk about whatever you want to talk about. But we can get into conditional uses. So I found that with any land use decision making, it's important to understand the distinction between legislative versus administrative, right? Is that something you guys have had a lot of training on or experience with?
A little bit.
Little
Some of
bit?
us, some are new, some are
Okay,
been here, so.
we can walk through it. So, it's important to understand, I think, right, from kind of what type of a decision you're making, what type of discretion you have, what type of deference a court is going to give you to your decisions, right? Things like that. And it's very different depending on whether or not you're making a legislative decision or an administrative decision. So legislative decisions, the planning commission, you guys act as an advisory board, right? Or in an advisory role, you make recommendations to the city council on legislative decisions. We're talking about when you're, adopting the general plan, enacting your zone map or approving a zone change, and then annexations, things like that. In those cases, cities are given a lot of deference. The courts, from a legal standpoint, give a lot of deference to the local governments to make decisions, right? And so, as far as a standard of review is concerned, it just has to be reasonably debatable that the decision is in the public interest, right? And also in accordance with any state or federal law that may apply, right? The pendulum swings a little bit when you get over into administrative decisions, right? And now at this point, the rules are set, and any application that comes in, you're just making sure that it complies with the rules, right? There's a few wrinkles when we talk about conditions on conditional uses, right? Which we'll get into, but generally speaking, when we're talking about conditional use permits or anything else on that list, right? Subdivisions, site plans, building permits, things like that. It's largely an exercise in making sure everything complies with the rules. And if it complies with the rules, then the application is entitled to approval, right? And then as far as making factual determinations or exercising any discretion granted by the code, you have to support those decisions with evidence, right? So that's kind of the high level general overview of the difference between legislative and administrative decisions. Any questions on that?
Can you go through the difference? Cause you, on both of those, you've got maybe development
Yeah.
agreements on both. Can you?
Great
explain a little
question.
more
Yeah.
detail of what-
So when we're talking about development agreements, some development agreements act as a zoning ordinance essentially, right? So a developer gets together with the city and they say, hey, we got this really nice piece of ground. We want to have do a really flexible kind of lots of amenities, a good development, right? And so you create essentially a new zoning ordinance through a development agreement, right? So you're legislating, okay? Those types of development agreements, the law says you have to make sure that they are ultimately approved the same way that you would pass a land use regulation, right? An ordinance or something like that. At the same time, the traditional use and the historic use of development agreements was largely just to kind of set the parameters and define the relationship, for lack of a better way, right? Who's gonna build what, on what timelines are we gonna build it? Are we all on the same page about what ordinances we're going off of and what's vested, right? So if a development agreement doesn't make any new rules, it just kind of sets the ground rules for how the existing rules are going to be applied. Then it's an administrative development agreement, and that one you don't have to put through the same process that you would have to put a legislative development agreement through. And so, yeah, that one takes a little bit of, rely on your staff, rely on your experts to help you understand, okay, do we need to pass this like we would a land use regulation, or can we do it more administratively, right? Does that answer your question? Is that helpful? Great. And then, yeah, for sake of time, I won't go into, we've kind of talked about all these issues. I will just point out, so the public's role, right, when making an administrative decision. It's important to recognize that that's one of the big defining differences, right, between legislative and administrative is what is the role of the public in that decision making. When you're making legislative decisions, when you're deciding how to zone an area, when you're passing a new ordinance, it's actually arguably essential that you get the public input, right, and find out, okay, what do we want our rules to look like that govern our community, and what are preferences and opinions and things like that. Doesn't mean that you just categorically go with what any one person says, but it's important to understand the perspectives, right? And consider that in making decisions. When you get into administrative decision making, like with conditional use permits, that changes. So if someone comes up and says, hey, I know that the zoning allows for this gas station, but I really don't think this is the right place. If the zoning already allows it and they submitted an application under that zoning, right, and get vested rights to the zoning, then that conversation has passed, right? The conversation of, is this the right place for that, right? That was done when you made your legislative decision, right? When you determined that this was a commercial zone that allowed for gas stations. When someone brings in an application and submits a site plan that complies with the rules, right? Then at that point, you no longer have the ability, right, to listen to opinions and preferences of the public and what they think is best, right? It becomes just kind of an exercise in determining compliance. Do you have a question? Sure. Okay. Because that's a really important part to remember. And often that takes a lot of education, right? For the public to understand and know, okay, what type of an application are we reviewing tonight? And is, you know, what is the role of the public in making that decision? Does that make sense? In the city, do you guys have public hearings for a lot of administrative applications?
Almost all of them.
Almost all of them, okay. And one consideration, right, one thing to keep in mind is state law does not require that you have a public hearing. So there's public meetings and there's public hearings, right? Anytime a public body meets, you have to do that in a public meeting, okay? But as far as a public hearing is when the public has a right to speak to something, right? And state law does not require you to ever have a public hearing for any sort of an administrative application, right? And it doesn't require either that you have a public body make the decision, right? So you can delegate the authority to approve or consider administrative applications to the staff. And if a planning commission keeps it, or in some cases, even a city council, there's nothing in state law that says you have to have a public hearing for those cases. Now, you always have to follow your local ordinance. So if your local ordinance says you do, then you do, right? But the city council can change those rules, right? If they want to streamline the process in certain areas or provide more predictability in those types of things. Okay, so let's talk briefly about the difference between a permitted and a conditional use. This probably will be review for many of you. So permitted uses are considered by right uses, as long, again, like we talked about in that administrative context, right? If it's the quintessential permitted use is like a single family home, right? If someone brings in an application for a building permit with a site plan that shows that it meets all the setbacks and elevations that show that it meet all the height requirements and everything else is compliant with the code, they're just entitled to approval, right? It's a by right approval, permitted use. Conditional uses, there are uses where there's a recognition that the use may have some unique characteristics, right? That the use is desirable in the community, but it may have some characteristics that are out of place for certain types of scenarios or things, right? So this, I think this is, by the way, isn't that the most beautiful picture you've ever seen of a Grantsville? Like, anyway, every time I see that, I'm like, that is amazing.
Is that Tooele Waste Management?
Is that what it is? Is that what it is? Is that in Tooele?
It might be.
It's just garbage. You can't really tell. I guess
It
it's
looks
sun.
like.
So I like to put this up because personally, and I'm no one's attorney here, right? But I think a lot of codes probably are over inclusive of conditional uses. They over categorize things as conditional uses, right? And this is just something to keep in mind and consider as you're looking at your codes, right? Conditional use, things that are designated as conditional uses should have unique and unusual characteristics, right? That don't necessarily comply with every and any situation, right? So there's kind of a list there, right? One that we really see often around here is religious uses, right? Churches. The idea is churches are great in residential communities, but the lighting, the parking, sometimes the traffic, right? It looks more commercial in some ways, right? And so that might be a use where it's appropriate to say, hey, you know, we're going to make this approved in residential areas, but we're going to approve it as a conditional use so that we can kind of look at the individual applications that come in, look at them in the context that they're being proposed, and consider whether or not reasonable conditions need to be imposed based upon the impacts that are going to be presented, right? Recreational facilities, gas stations is another real common one. Landfills, gun clubs, you can see it all there. Gravel pits is the beloved, you know, right? Okay, so some additional things to keep in mind then when we're talking about conditional use permits. And these next slides are going to have a lot of words on them. I apologize, but you know, we can distribute them and you can read them at your leisure later, right? We're doing all right? Yeah, we're doing great. We might even get done by 6:30. Any questions so far? Anyone? It's riveting stuff, isn't it? Okay. State law says, so I'll just read it. A municipality may adopt a land use ordinance that includes conditional uses. Okay, we're good so far, right? Provisions for conditional uses that require compliance with objective standards set forth in applicable ordinance. So that, here, I'll just go ahead and give some examples, right? So I actually pulled this from, this is Harriman City's code. And I thought they had a pretty good list of the types of standards that are useful, right? And that you could consider to be objective standards, right? So we're talking about setting forth concepts that you need to consider with conditional uses, right? So they're not specific and defined rules, right? Like the building must be 35 feet tall, but they're more general standards that you look to from which you can impose rules and conditions, right? So impacts to street level, service levels and traffic patterns, utility systems. And keep in mind with each of these, right? If you look at it, in order to know whether or not there are going to be impacts, you need additional information, right? Often you'll need a traffic study or some sort of a engineering study about how it's going to affect utility systems or connectivity, or what the use is going to look like and what types of noises, odors, and environmental impacts it's going to produce, right? Is there a need to limit hours of operation? So you need additional information to know whether or not you need to impose additional conditions, right? And so that's just something to think about as you look at your standards in your ordinance. How do our standards cover the important things, right? And do they do it in a way that we can look to them and address all the potential impacts that may come along? Part of the reason for doing that is understanding that if you don't have a standard that you can point to and say, hey, this detrimental effect, right, is related to one of these standards. If you can't do that, then you don't have authority to impose conditions, right? So you have to connect every condition that you impose to some standard in the ordinance, right? Any questions about that?
Yeah, we encountered that not long ago, so.
Okay.
I think we understand it better, but
Okay.
just
Yeah.
interesting hearing it coming from your mouth.
Experience always produces these kinds of things, right?
Well, absolutely.
And Jordan, yeah, we have talked about it, and I've talked about it with other clients too, where we.
Is Jay the city attorney?
Tyson is.
Oh, there you are, Tyson. Okay.
No, I'm special counsel on land use.
Okay, perfect. Yeah.
So when we talk about this, a lot of what we're doing is identifying exactly that gap you just pointed out. If we don't have something, then we don't have an objective standard to point to. And is it something that we can't write a rule about right now?
Mhm.
Is kind of the next question. So if we can write standards, like actual standards of, well, if we have a berm that's 3 feet high that addresses this lighting issue, then why not just write that in?
Right.
And the answer would be, well, we don't need a berm in some locations, but we do in others. That's why we need the additional.
Great.
But anyway.
Yeah.
Or if we have a commercial property that is adjacent to a residential property and that the hours of operation are into the wee hours of the night, and they potentially may have what I would consider on this fourth bullet point, environmental impacts. It doesn't list garbage, but you could.
Sure. And
you could tie that to a certain type of barrier between the property and, well, the two properties, essentially.
Mhm.
So we could put that in there, right?
Yeah.
So, but it would have to tie to that particular detrimental effect and state that this is how we mitigate that detrimental effect.
Yeah.
By imposing that conditional use on that property owner. Correct?
Yeah.
Like a fence,
Right.
like a concrete fence.
We've had, in a lot of communities, we've done away with conditional uses for daycares, for instance, because we identified there's one reasonably anticipated detrimental effect. And that is traffic and drop off and pickup.
Yep.
And so we wrote the standard that they have to have a pull through drop off system.
Yeah.
And then it's like, well, if you
And
require
everyone
this,
just complies with that.
then it's permitted if they comply.
On four there, the unreasonable or atypical, is that pretty stringent then? It has to be? Cause if it is reasonable, then it doesn't fall into that category?
Yeah, so those words, and again, this is Harriman's example, right? Those are the kinds of words that you want in there to try to make it as objective as possible, right? You want your conditions that you impose based upon your standards to be reasonable. Every lawyer's favorite word is reasonable, right? Because everyone has a different opinion of what that means. But the less reasonable your conditions look, the more you expose yourself to potential liability of being sued that your condition is not reasonable, right? And so, yeah, I mean, those kinds of words are put in there to hopefully guide the decision-making and make the standards a little more objective, if that makes sense, right? So you're not just looking for any impacts, but you're looking for unreasonable or atypical noises, odors, right?
So, just to be clear,
Yeah,
Jordan, if we've allowed a barrier between residential and commercial to be chain link fence in other areas, but then require a new commercial to put up a concrete fence, is that reasonable?
okay, so that sounds very specific. And so my best answer in those cases is consult your legal counsel, right? But yeah, if you're acting in a way, just as the guy who doesn't have a dog in the fight, right, and gets to say whatever he wants because he's the trainer, right? You do want to be consistent, right? Consistency is for no other reason than to minimize your risk of exposing yourself to potential liability, right? Perception is valuable, right? I mean, if people perceive that they're being treated unfairly, then they can create issues, right? And I'd say from a legal standpoint, right? Yes, the law requires that you treat people who are similarly situated similarly, right? And you know, I get that fencing can be one of those areas where this is an issue. Actually, I'll just put this out here, right? That kind of the players in the industry are talking about a lot as far as what kind of standards you impose, whether that's road widths or, you know, sewer trunk line sizes, even private facilities, right? Like fencing or the piping of a ditch or something like that, right? What you hear from the developers is, man, cities more and more are wanting us to gold plate their roads, right? But you have cities who are saying, hey, well, we need to follow best practices, right? And have infrastructure that's gonna last and that's gonna serve our community for a long time. And so that's kind of the tension, right? And hopefully everyone can agree upon and kind of keep within the bounds of what everyone's sensibilities are of reasonableness, right? But that really is kind of what you're trying to do.
So it's the people that are lobbying for those maybe that want the gold roads because they own the gold manufacturing plant and they're gonna make a lot of money or.
You are asking questions above my pay grade.
I'm just making.
But yeah, you all interesting considerations,
Yes,
right?
very interesting. Thank you.
And yeah, so I'll come back to this. This is kind of just, I think it's fun to talk about, right? We talk about, okay, is it a standard or a rule or condition, right? And I read one time kind of the difference. So standards, like we talked about, you need to know more information and they're kind of general and broad, right? And then from those standards, you create conditions which act as rules, right? Hours of operation will be between the hours of 8 and 5, right? That's more of a rule. Once you know the situation, you just apply it and you're good to go, right? And so that's kind of the way I conceptually think about the difference between these standards and then conditions you'll impose based upon those standards, right? How are we doing? You got a couple more minutes? So yeah, and this just kind of reiterates that point, right? So the standard can't, and objective standards, right? They require a degree of specificity, can't be so general as to allow unchecked discretion. Anytime people start throwing around the word arbitrary, you know you're in a dangerous place, right? With land use decision making. And so there's some examples, right? Unchecked discretion, it will not adversely affect the public interest. That is actually in a lot of ordinances, that language, right? And I think it has the potential of getting cities in trouble because it doesn't give appropriate guardrails to the city decision makers. And they make decisions that people challenge, right? And may be considered frankly arbitrary, because the court might look at that and say, man, there's no governing principle here, right? Whereas a more objective would be, won't adversely affect street service levels or traffic patterns. From that, you can get a traffic study, right? And from that traffic study, you can say, okay, how are service levels affected? How are traffic patterns affected? And that gives you a lot more credibility, weight, evidence to be able to impose a condition for maybe a turn lane or something like that, right? Okay, so here's another one of those lots of words slides. So you have to have reasonable conditions. This I'll just again read. A land use authority shall approve a conditional use if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. You know that an attorney wrote that, right? It's got a lot of the fun words. So I kind of like to think of it, okay, what are the steps that we follow, right? So first, you have to identify those reasonably anticipated detrimental effects, right? I mean, and again, all those words are kind of designed to hopefully keep everyone in the guardrails, right? Yeah, it can't just be mere total speculation, right? This might happen, right? There might be dust or there might be traffic impacts, right? They have to be reasonably anticipated detrimental effects. And then once you've identified an effect, then you go to your ordinance like we just talked about, and you ask, okay, is there a standard governing those anticipated effects? And if there is, then you can come up with a reasonable condition, right, to mitigate the detrimental effect. Now, again, some people will say that a concrete fence in certain case, or a concrete wall, right, is going to be unreasonable in some contexts, right? But in other contexts, everyone will agree that, yeah, it is going to be reasonable, right? And so sometimes this is just a practical consideration. It might be worth it to have a little bit of negotiation, right, with the applicant and discussion to see, okay, what is being proposed here? And does this sound reasonable to you, right? And if everyone's on the same page, you know you're golden, right? You won't always agree, but sometimes that conversation is appropriate, right? And then the other key term is to mitigate the detrimental effect. So the law specifically says reasonable conditions don't have to eliminate the detrimental effects. They just have to mitigate them, right? And if they can be mitigated, if they can be lessened, then they're entitled to approval, right? So yeah, and I think we've had a pretty robust conversation on that, kind of looking at the standards, what kind of potential conditions you could impose. Any questions or comments about that? Thoughts or ideas? Cool. Okay, and then it's important. So I have the first three steps there that we saw from the last slide, and then I've added a fourth step, right? So your conditions need to be stated in the record. They need to be supported with evidence. So here's some just language that I pulled from different court cases. Decision makers must provide reasons when they make their decisions. They must disclose the steps by which it reached the ultimate factual conclusion. They have to make findings of fact and conclusions of law that are adequately detailed. And then the failure of an agency to make adequate findings of fact and material issues renders its findings arbitrary and capricious. That word we don't want, right? And so whenever you're making your decisions, imposing your conditions, it's like your teacher always taught you, right? Show your work and provide the evidence for why you made the decision you made, whether that's a traffic study or some specific factual finding, or the opinion of a public safety officer, if it's something related to that, right? All those types of things are evidence that can help you to support your conclusions. Any questions or comments about that?
I love those steps. I wish I had those when I was training people on how to do environmental review. Those are great steps. Thanks, Jordan.
You bet. And then the last thing I'll point out is when can we deny a conditional use permit, right? So up until 2 or 3 years ago, we could confidently say that there had never been a case where the denial of a conditional use permit had been upheld by the courts, right? Now we have I think maybe 2 examples now. The first one was, it was a parking lot in Springdale, Utah. So you know how they do the shuttles now into Zion's National Park? Someone had a great idea to make some money and do a parking lot that people could park in and then shuttle, into town. And they wanted to put it in the middle of a residential area. And apparently the studies that were done showed that, yeah, there was going to be a pretty significant impact here. And so the city made the decision maker made a finding that, hey, we really sincerely don't believe that there is any sort of a reasonable condition that could be imposed on this that would sufficiently mitigate the detrimental effects. And the Utah appellate courts looked at that and said, yeah, that they provided sufficient evidence, right? But the cautionary tale is it's happened very infrequently. And if you are kind of in that mindset of, wow, I think we should deny this, again, my advice is consult your legal counsel, consult your staff, and make sure that you have the evidence to support that kind of a conclusion, because it needs to be pretty good evidence, right? Okay, I had an example, we don't need to go through that, from West Jordan City about just kind of what that looks like in practice. I'll just close with, and we touched on this already a little bit, right? So, yeah, we actually already did talk about public hearings on proposed conditional uses, right? Just keep in mind that state law doesn't require that you have them. I think the value of public input in the administrative context is if you can train your public really well, that we're looking for facts and evidence, right? The example I always like to give is maybe someone has a commercial site plan they're proposing on a historically agricultural property, and they bring it in and they put it up on the screen, and Farmer Brown in the corner says, oh, hey, are you guys aware that I have a ditch that runs kind of diagonally through the property that I use occasionally or periodically, right? Again, not that will shuttle or kibosh the proposal, but that gives you evidence and information to say, hey, how can we address this issue, right? But if people are just getting up and sharing their opinions and preferences, and then in some cases it might make sense to not hold public hearings in those cases, right? If people don't understand kind of the purpose of the exercise. And then Jay touched on this a little bit. So there's a trend moving from having conditional uses in your ordinance to having just permitted uses with carefully tailored design standards. So I pulled this, and you can't even really see it, but I pulled this example from Provo City's ordinance. So they have for recreational vehicles and boat sales lots, it was determined, right, that hey, every time a RV or boat sales lot application comes in, we're just like copying and pasting the conditions from the last application into the new application. If you find yourself doing that a lot, then just make it a permitted use and put those design standards in your ordinance, and then everyone that comes in just knows that, hey, whenever I am proposing a boat or RV or boat sales lot, these are the things I need to do, right? It goes through fencing, yards and landscaping, vehicle display areas, that gets into parking. So this takes a little more effort, right? And a little more resources, but it also adds to transparency and predictability. So that's just something to keep in mind. And again, it's not ideal in every case, but it's a very workable solution in many cases. So with that, thanks for having me. There's my contact information. You can pass the slides around to whoever you want. And if you have any follow-up questions or anything, feel free to call me or email me. And there's our website there, which we get good feedback on, that it has great resources there. And I appreciate your time. Any final questions? Okay, have a good evening, guys. Thank you.
Thank you.
No
for coming.
questions?
Thank you.
Yeah. You have a question, ask a question?
Well,
You
I
can
just
ask.
wondered if you could
Do
like
you want me
touch
to?
on,
Yeah.
and you kind of did, but can you like kind of touch on the difference between a variance and a CUP?
Oh, okay. So yeah, a variance,
Sorry,
those are very different things, right? To be honest, right? A conditional use permit is something that is permitted and it has unusual characteristics that may warrant the imposition of reasonable conditions. Variance is when you have a situation where someone is coming in, they're applying under the ordinance, and the way that the ordinance applies to the application, it creates a situation where the property owner isn't able to do with their property what everyone else in the zone is able to do, right? So of no fault of their own, right? And so we're talking about scenarios where maybe there's certain like geological characteristics or formations or hazards or environmental like wetlands, right? So maybe someone comes in and, you know, they show where they want their home on the property. And then you look into it and it's like, oh man, like half of that property is wetlands, right? And so, you know, the building footprint is gonna be 10 by 10 feet because of the setbacks, okay? In that case, you might consider encouraging them to go through the variance process, right? To say, hey, does it make sense to relax some of the setbacks here so that, you know, you have more area on the lot to build something that's going to be useful and reasonable, right? Because you are granting an exception to the rules when you do a variance. And so the law says you can only do that in very limited cases, right? When
Sorry,
people have
would you
hardships.
guys that just walked in, please sign in.
And so, yeah, variances are intended to be used in very, very limited circumstances. Often people will come in and say, hey, I'd really like to build not, you know, I'd like to go beyond the setbacks, but you look at the setbacks and like, well, it's reasonable and everyone else seems to be able to build within them, right? That's not an appropriate use for a variance, right? And they could propose an ordinance amendment, right? To say, hey, maybe we should relax our setbacks across the board for everyone. But there's no like individual hardship that anyone is experiencing in those cases. Is that helpful?
Mhm.
Okay. All right.
Thank you.
Thanks, everyone.
All right. I'll make a motion that we adjourn. A second, all in favor? Aye.
I'll make a motion, we adjourn.
Second.
All in favor?
Aye.